सभी गुरुजनों को नमस्कार। मैं शास्त्र संगीत गाने वाली हूँ। I'm going to sing शास्त्र संगीत. The raga is Vrindavan Sarani.
Thank you, Madhuri, for the blissful song. Thank you. Now I invite Betty John, first year student, Department of Law, Central University of Karnataka, to introduce our distinguished resource persons.
Good afternoon. It is my pleasure to introduce the eminent scholars and honored guests to this technical session. Honorable Justice V. Sri Shananda, Judge, High Court of Karnataka. Senior Advocate Sri M.B. Nargun, High Court of Karnataka. Honorable Justice V. Sri Shananda, Judge, High Court of Karnataka, is the distinguished speaker of this technical session. Your Lordship has masters in law and had about 20 years of practice in various parts of our country, especially in metros like Delhi, Mumbai, Chennai, Kolkata, and Bangalore. In 2008, Your Lordship was selected as Principal District Judge. directly after about 18 years of glorious service. And from 2008, Your Lordship has worked in various capacities as additional district judge and then principal district judge in places like Gulbarga, Dharwad, Karwar, so on and so forth. In recognition of his illustrious service to the legal profession in bar and bench, Honorable Justice V. Srishananda was elevated to the High Court of Karnataka in the year 2020. Your Lordship has the word knowledge, which comes from the Sanskrit root Veda, in his name itself. In fact, Honorable Justice V. Srishananda is basically Honorable Justice Veda Vyasajar Srishananda. The word Veda is embodied in Your Lordship name itself. I welcome you to this session, sir. Next, I would like to introduce Sri M.B. Nargun, Senior Advocate, High Court of Karnataka and the former Additional Solicitor General of India. Sri M.B. Nargun has been practicing as an advocate in the High Court of Karnataka since 1982. He has been distinguished as a senior counsel by the High Court of Karnataka on 14 July 2014. He is specialized in the field of civil and constitutional law. He has served as standing counsel for the Food Corporation of India, Central Bank of India, and Karnataka Film Industries Development Corporation, Pune. There are various judgments which have been reported in reputed law journals where he has represented the cause of his clients. Apart from being an active member in bar, he has also been active in various socio-legal organizations. He has delivered many keynote addresses in seminars conducted by Bar Council of India and State Bar Councils. He has been awarded the prestigious Karnataka Rajyotsava Award in 2011, which is the second highest civilian honor. And having held the position of Additional Solicitor General of India for the state of Karnataka. I am so proud to introduce such a senior advocate to this section. I welcome you to this technical session second, sir. I am very much delighted to invite Sri Amit Kumar Deshpande, sir, Senior Advocate, High Court of Karnataka, Trustee, Vijnaneshwara Pradhisthana Trust, to felicitate Sri M.B. Nargun, Senior Advocate, High Court of Karnataka. Once again, I welcome you both to the technical section too. Thank you.
Now it's time to start the fruitful session of our conference. During the inaugural session, our Honorable Justice V. Srishananda said that he is only given as a trailer and the rest of the part we are excitedly waiting. And with respect, I invite Honorable Justice V. Srishananda, Judge, High Court of Karnataka, to take over this session and to give his valuable knowledge and to share the knowledge with us. Sir, please.
Good afternoon. Nobody need to get feared with the bulk book that I am carrying. The gist thereof will be presented to you with the best of my abilities at my command. Sri M.B. Nargun, a senior advocate who has seen me even before I became an advocate, dignitaries of the dais, the resource persons who had successfully conducted the first technical session, made my job easy. you now know, understand the nuances of what the Mitakshara meant. As in the morning session itself that I have put it across, the topic is applied science of Bharatiya jurisprudence. See, if we split the words, Mitakshara is the focus, that is the base. Whether Mitakshara could be the applied science with the Bharatiya jurisprudence is the topic that we need to ponder over. I am aware that most of you had the delight and wonderful lunch. So my job is now not to make you sleep. The applied science was the word which myself and Mr. M.B. Nargun pondered over in my chamber 2-3 days, 4 days earlier. Then a concept also cropped up that it could be termed as a social science, therefore the topic may be somewhat akin to the modern era. Those of you who have gone for the Ooty or Kodaikanal would have seen the coffee being prepared by a person like this. Even in Rajasthan, the badam milk is prepared in that fashion, but that fellow will also be revolving. So, person like me thought that the longer the hand goes is the measure. So, I went there and then asked him, "Arey bhai, I want 1 meter coffee." That fellow laughed at me. "What do you mean by that?" "No, I thought that this is the way, so I need 1 meter coffee." So, if you want to measure the Manusmriti or the Yajnavalkya with that yard, measuring yard, this is the absurd result. With respect to the all the academicians and the so-called empirical study, which the people now stress upon for the research work is concerned, I would like to commence this lecture with a humoric tone. The empiric study goes like this. An applied science was effected. A frog was brought and put on a table, and the fellow said, "Hop." Frog hop. That is the nature. Nature of the frog is to, when you touch or when you bring your hand near that and then say hop, it will hop. Even if you don't say hop, it will hop. That is the nature. So what the researcher did is, he cut one leg in the hind side. Again he touched the frog and said hop. With 3 legs, somehow the frog hop. 2 minutes later, he cut the other leg also on the hind side. Now the frog has got only front legs. The body weight is on the hind legs. That was used for the purpose of hopping. With somehow some difficulty, to save its life, it hopped for a shorter distance. Then the one leg on the front side was also cut. Now this man is saying, the researcher, hop, hop, hop. With one leg on the front side, the frog could not hop anymore. So, result आया, the study, the applied science, the research methodology, empirical study, practicality, everything put, and then the final result of the experiment is, when the third leg of the frog is cut, frog becomes deaf. Such absurd results we get often when we try to understand one system with the measuring yard of an altogether different system. Hope I have set the tone to understand Vijnaneshwara. Vijnaneshwara, as you could see in the photograph here, was not a Rishi as is portrayed in a movie. Please understand this. A Rishi need not be what is shown in the movie. Moment a Rishi is said, the movie people has made us, he should be having saffron colored dress, a dhoti, and a stick that is called danda and kamandalu, and he must sit beneath the tree and then keep on chanting something. No, that's not the meaning of Rishi. If somebody understands the meaning of Rishi from the Sanskrit angle, it is somewhat synonym to the researcher, not the researcher who did with the frog. No. The Rishi has got a purpose to achieve for the society. Please understand, this is the only country which has given the result of an experiment free of cost to the society at large without expecting anything. Forget the IPR, forget the intellectual property rights. No Rishi of this country wanted anything in return for the best of the benefits that they got. They gave it. In our day-to-day Sandhyavana mantras, day-to-day other mantras, even the Satyanarayana Puja, take the works of Mirabai, take the works of Kabir, take the works of Basavanna here, take the works of our Dasa Pantha. None of them wanted anything for themselves. They all wanted to give it back to the society because they are from the society. Their only intention is to how to purify the society, how to work out for the well-being of the society at large. Bahujana hitaya, bahujana sukhaya, means to say large section of the societal people must be protected from evils. The evils could be inside or outside. The outside enemy is easily spotted. We know, bordering nation, we have enemy in the form of China, we have enemy in the form of Pakistan. We can fight them. There is no problem. How to fight the inside enemies? How do you identify who is this fellow? This is where the problem occurred then also, now also, and continue to occur. This will spoil the harmony of the society. With this angle, what our people have done, how they brought the rule of law, how they established peace and tranquility, which are the concomitant factors for the well-being of the society at large. And it was the duty of the king to maintain both. Harmony in the society, peace and tranquility, invasion from the enemies. These are to be protected. If somebody who is very keenly now reading the fourth part of the Constitution, namely the directive principles, these values are even today available. In the place of Raja, we have the elected government. Now let us see what Vijnaneshwara did for the Yajnavalkya. In the morning session itself, I have told between Manu and Yajnavalkya, there is a hell a lot of difference. Other resource persons in the morning also gave little bit idea of why Manu and why Yajnavalkya and why not Manu. Manusmriti, my friend has said Smritis are 2500. Westerners now have agreed that it is 2000 BC. So it could be 4000 years. Whether it is 2500 or 4000, let us not get into that. Nor I am trying to discount any other jurisprudence, please. I am not of that nature. Ano badrantu kutavaha is the Vedavakya. Let the noble thoughts come from any nook and corner of the world. I am going to keep my faculties open and assimilate the best practices. This is what has been there, this country has been doing with the meaning of what is called Vasudhaiva Kutumbakam. The whole world, this Mother Earth, whatever that is propagated, resonated from one part of the country, from one part of the geographical piece of this particular world, if it is a good practice for me, nothing wrong in accepting it. I am wearing a coat. It's not only for the purpose of protocol. Yes, coat is good. Coat is good for whom? Where they are working for the cold. I am wearing shoes. Yes, it is for protection of my feet. Why not I accept? I accept. There is no wrong. So therefore, at that point of time, who was the first to give best to the world? Do you have any text? Ask anybody. Here and here alone, I would like to quote Derek. John Duncan be direct. Since morning I was trying to find time where to quote direct. My dear friends, Derek is a British Army officer, Air Force officer who came to Bangalore sometime in 1920s. Please understand, I am not talking something, 400, 500, 10 and 1000 years back. He came here in 1920s as an Air Force officer. He stayed in Bangalore Jalali as an Air Force commandant. His father sent him to Bangalore only with an intention that he could be saved for the rest of his life because the World War II was in progress. Derek came to Bangalore. One Mali of the garden looked at him and said, "Sir, you are going to become Orientalogist just by face reading." Derek was confused. He could not assimilate it. One Mali who is working in the garden, pruning the plants, how can he predict my future? And what did he say? For an Air Force officer, he is trying to say that you are going to become a Orientalogist. Oh, something funny. In the initial stage, for a few hours, he discounted that idea. He must be blabbering something. But he did not get sleep in the evening. Night. Next day morning, he was waiting for that Mali to come to find out how he came to know. Unfortunately, what was told to Mali by others, Mali got feared and he did not come to the work on that day. So next day passed on, days passed on. Fourth day, Derek goes to the Mali's house. Now this fellow is now sure that he will be killed. So he hid himself in the house. And he called him with assurance, nothing will be done of that sort. See, he came and asked him, what made you tell me, predict me that I am going to become an Orientalogist? Story goes on and all these things. Ultimately, he presented a PhD thesis for the Mysore University, got the PhD thesis on Hoysalas as to Shilpa Shastra. And the World War II was over, he went back to England. But after studying the Hoysala Shilpa Shastra and other aspects of the matter and other nuances which was available in Sanskrit, his urge towards to learn the Sanskrit was ignited in himself and he wanted to come back to India. So he asked which is the best place to understand the Sanskrit. People said, Sir, Kashi, Varanasi, Banaras is the best place. So he came to Banaras and asked few Pandits, take me as a disciple. I want to learn Sanskrit. All of them discounted. They said you should wear an attire like Dr. Naveen. You should have shika. You should stand in the flowing water of Ganges to the neck level. Then only your tongue will twist for the Sanskrit words, otherwise not. So he said, all that is acceptable to me. Take me as a disciple. Pandit, having given all these conditions, had to accept because the promise, if broken, what happens in Hindu law, we know. So he had to accept. Next day morning, flowing river, Derek is there. This Pandit comes to take the bath and do his morning rituals. He hears a sound, Guruji, I am here. He looks at it, the fellow who was there, well dressed in a suit like this, previous evening, is now with a shaven head, having shika, having the dhoti, no upper cloth, and up to this level in the flowing Ganges. He accepted him, literally thought in Sanskrit when Derek was around 40 plus. My dear friends, he became the professor of Hindu law, Orientalogy, after studying Parsis, after studying Christianity, after studying Mohammedan law, after studying all other available laws, Jewish, Yahudis, whatnot, and ultimately said that Hindu law is the best code. It is not me saying, it is the words of Derek. He has written. There are 4 beautiful books called Classical Essays on Hindu Law by J.D.M. Derek. If the library does not have it, I would request the law department to have those 4 volumes, and that any person should read that as a ritual every day who is interested in Hindu law. Friends, till I had I came into contact with my professor who is my father's classmate. I was also ignorant, like many of you, who has not even heard of the word direct. Forget studying direct. After I went for the research paper to be presented for Annamalai University for my ML, I came into contact with my professor, Professor B.N. Sampath, who has written a beautiful book on Vignaneshwara in Kannada. I am able to get that 10 books from his wife, who is now at Mysore, and then give it to the Pratishtana test. Those who have got knowledge in Kannada may read it. Owing my all pranams to my Guru, Professor B.N. Sampath, who was the Hindu law professor for 33 years in Banaras, I would like to now attempt few items of Vignaneshwara, the importance, nuances of Vignaneshwara in the angle of applied science. Friends, since morning we have understood that Mitakshara is a work that has been, a commentary that has been, a vivruti that has been made by Vignaneshwara sitting at Martur. Martur is not far off, about 10 kilometers away from Kalburgi. Those who come from Bangalore in the train can even spot the station Martur. Unfortunately, Maretu in Kannada is forgetting. It has become Maratur. We have forgotten the very place itself. Is it justified? I would request the law department people, including the Vice Chancellor, sir, make a day's trip there. Let our friends spend some time, good time there. That resonance, that positivity, that vibes, let it come and flow to our children here. Such a beautiful soul was Vignaneshwara. His names, his father name, everything, now that there is there. And this was not even known to many of the Karnatakans as well. Till a professor from Dharwad made research about Vignaneshwara, and that professor's work somehow came to the knowledge of Dr. M. Ramajois, who is a close friend of my father. And when I took up this issue of studying the Smritis as my LLM thesis, I went to Ramajois and took his blessings. He said, God bless you, at least one soul is there who is taking the torch further. With that intention, I studied for the purpose of my thesis. Then I came to know what the treasure that we had, the hidden treasure. Unfortunately, we have such a huge treasure and we are only working for 2 minutes Maggie. We have full meals available. We are working for 2 minutes Maggie. If you want to satisfy with 2 minutes Maggie, have it. I have no objection. So my purpose today is not to condemn any system, but at the same time understand what Vignaneshwara gave it to us from the scientific angle. My dear friends, we are only talking of inheritance in respect of the property, though Vignaneshwara has touched upon many other aspects of the matter. Since morning we have seen how beautifully structured, codified system that he gave it for the rule of law to be in place, and also to easy way of resolution of disputes, including the present day work that has been pressed into service as if it is an alternate dispute resolution system which was not known to us. Sorry, if you go to any old movie, if you see a panchayat scene, whatever that Yagnavalka, whatever that Vignaneshwara has propounded, you would see one person coming giving a complaint to the panchayat das, a lady, sir, this fellow did like this to me. Then he will convene a panchayat. The lady is expected to tell in front of all the villagers who are assembled there what is her case, and he will ask the other fellow, are you agreeing or not agreeing? If you are agreeing, what is the punishment? If you are not agreeing, we will have the proof. So one or two persons will be there. Did you see her in the company of this fellow? Did you hear what she said? All these things, this was there in the group. How this could come to panchayat? Whether any school of thought was there? No, it was there in our blood. It was there in our genes. It was there in the progress. It was all there much earlier. Even before the people know how to put a tie, how to put a shirt onto their butt, on their body, and they did not know how to put a button onto the shirt. Such was the primitive civilizations people had elsewhere in the globe. At that point of time, we had here the university in Malakheda, in Sedam, near Sedam, Malakheda. It is called Manyakheta. The university was there. Across the globe, people used to come here as if now we are going to the Texas, as if we are now going to the Oxford, as if now we are going to the Cambridge. People were coming to Manyakheta in Kalburgi, sir, for studying the beautiful knowledge which we had. What happened to it? If somebody goes to Malakheda today, you would only see people spitting the jarda. We don't want, sir. In Kannada, there is a proverb. Hettammana amma annadavulu, attammana amma andale. I'll translate it in English for your benefit. If you don't call your mother as mother, will you call your mother-in-law as mother? Howsoever ugly your mother may be, it is your mother. Any other film actress, take anybody who is good looking, Deepika Padukone or somebody else. Imagine whomsoever as your mother and go and kiss her. You will get a slap. That is what we are doing. We are forgetting our mother and we are going to try and kiss somebody else as our mother. Sorry, we are doing wrong. I am very sorry. Our forefathers did it, maybe under pressure, maybe under the invasions, maybe for whatever be the reasons. My generation has already suffered. I should not allow this syndrome to continue, and it is our endeavor at this point of time to cut that syndrome and make our young souls to flourish and share this knowledge. It is now available in English. Those who can't read Sanskrit can go, and this is the head of this particular book itself is Forgotten Books. And I'll give you the website address www.forgottensbooks.com. That's all. You go there. You can also download. Be careful, copyrights are there only for personal purposes. Right? I have the original text that is highly mutilated, therefore I have downloaded it for the purpose. Now let us understand how Vijnaneshwara stood different from others. Manu, in the morning we said that he gave a rational idea, and at that point of time, relevant point of time, everything was religion oriented. You can't bypass. Today, everything we need the scientific answer. Show me where the air is. That joke everybody has understood. Sir, air is everywhere. A fellow was caught with a bicycle. He said, where is the light? He was not having a dynamo. He said, light is everywhere. Then he removed the wall pin and said, air is everywhere, you go. So that scientific answer we wanted. That scientific answer now we want, because we want to measure everything scientifically. You must now go back to 1000 years earlier. At the 10th century, 11th century, people wanted everything to be associated with religious angle, and the people were required to answer it in that chaukat, in that framework. Therefore, everything was tried to be explained in the religious way. Now we are having the scientific way. If we have explained it in a religious way, we can also explain it by the scientific way, because truth is one and the same. The way of explanation is different. If you know how to prepare rice, you can prepare picture rice, you can prepare bisibele bath, you can prepare bal palav, you can prepare jeera rice, what not. Any rice item can be prepared, provided if you know how to cook the rice. What is the issue then going for the specialization? This is where our children are put to. That is where the Yajnavalkya come to our aid. Yajnavalkya systematically made, we have seen the 3 chapters, and chapter wise he has dealt it. In the chapter there are sub chapters, and inheritance is what we have to look into. where we can abundantly see the applied science being used by him. I'm only taking the one word called sapinda. Now this particular verse comes from eligibility criteria for a bride. Today also it is there. We have section 12 in our Hindu Marriage Act, which would say if any of the spouses are impotent, then the marriage is a nullity. Very simple suit. We are doing it day in and day out. Unfortunately, the limitation is only 1 year. Does it take 1 year for anybody to understand that his companion is an impotent? Please tell me. Very next day, Aliyana Kurdu Bedagadare is the Kannada proverb. If the groom is blind, it will be noticed the very next day morning. So is the impotency, sir. So therefore, 1 year was put. What we are doing? In a case where the person is impotent, we are filing a suit for divorce. Where is the clarity? Eligibility criteria. There he says, asapindasya. That is the first criterion that the Yagnavalkya uses. That means to say, you should not marry your sister. Very simple point, very scientific way. How a sister is made now? You should not marry your sister. You should not marry your mother. You should not marry one who is having a blood relationship with you. This is where the Yajnavalkya made a beautiful understanding in using the word askalitasya brahmacharyasya asapindasya. These are the shlokas that are available. One can go through that. For the sake of brevity of the time, I am not reiterating the shlokas. So you can't marry any blood relative. What happens if I marry? This is when my professor left National Law School of India. He was teaching Sapinda relationships. Influenced by the Westerners, one boy said, "Sir, what if I marry my sister?" My professor got annoyed and put in papers and went back and settled in Mysore. And he told me, this fellow asked me like this. I said, sir, those are all the people who are there available even in Yajnavalkya's period. Forget and then move on. But he was very much touched, a very pious professor of Hindu law. Having taught for 33 years, the people could not anyway assimilate these things any further. So he left the National Law School. Why? What happens in a scientific angle? Let us now see. What the Sapinda means is the religious angle they used to say. Sir, please. As all you know, the word pinda, it is used in the very slang language. The religious meaning that they gave for the pinda was a rice ball. Many of us would know. It is across the country, people know the meaning of pinda. Pinda is offering a rice ball for our elders who are no more. So the religious text thought that pinda means the one that is offered as a funeral part of the funeral ceremony and the obsequies thereof, once in a year. So the Grantha came called Parivana Shraddha. Parivana is a plate. Parivana is to be understood as a big plate where the pindas are kept and that has been offered. This is called Parivana Shraddha. Parivana Shraddha was based there in the place, and whoever who does this will get the property. This was the interpretation given by the other commentators. And therefore, since he is offering the pinda for the departed soul, and that whatever the wealth that that particular person has, and that is going to be enjoyed by this fellow, there are some other shlokas for that also. How the lineal decidency has come and other things. Who is the person who is entitled to offer the pinda? If a Mysore Maharaja were to die, I am also ready to offer pinda to him because I will get the palace. If this interpretation is to be accepted in that fashion, I am ready. And there will be a big queue only to offer pinda. Was this the interpretation? Was the question that came into the mind of many. Mind of many. As you know, the success has got many fathers and failure is an orphan. Aputrasya gatam nasti. This will go hand in hand. If a person doesn't have an adhikari who could offer pinda for the departed soul, then he will not get the property. So what happens to the female heir? If I have got only 2 daughters, what will happen to my father? If I got only 2 daughters, and if tomorrow I die, my daughter cannot offer pinda to me, what will happen to me? Then came what is called dattaka. You can take somebody other than your gotra. That means to say, he must not be from the same gotra person. He can be from some other gotra. You adopt him and treat him and rear him as your son so that he can offer pinda to you, and then that person will get the property. Now you see the inequality. Daughters who are born to you are denied the share, and fellow who is somewhere there, what guarantee is there that he is going to do your pinda pradana every year? And just because you have the dattaka, you are not there to see and check whether this fellow, but he has been given a share. So people started thinking. There was a heartburn across the society. Where will I go? Then came the Yagnivalka, which made this particular aspect here, and he tried to explain what is the meaning of Sapinda. What he meant, Yagnivalka, could not be assimilated by the commentators. They went in a traditional way and understood that, this is the progeny that has been, therefore, they can only offer, but it is the Vijnaneshwara who gave the meaning of Sapinda from the scientific angle. Beautifully, he quotes a shloka from the Garbhopanishad. It's a beautiful, my dear friends. Today, soon after somebody is tested positive for the pregnancy, you go and contact a gynecologist. Gynecologist will give a prescription, some folic acid tablets, and then 16th week one ultrasound scanning. Again at the 5th month another ultrasound scanning. Again in the before 7th month there is one ultrasound scanning. So many prescriptions will be given, so many blood tests, etc. will be given. As a ritual we follow. We don't ask the gynecologist, doctor, when I was born, when my mother gave birth to me, this machine was not there. Am I not healthy? Why should I now do it for my wife? Nobody will ask. Doctor has said you have to do it because it's a scientific way, no? Applied science has got so much of confidence, no? Give a bottle of water. We think that it is pure. What guarantee is there that it is taken from the very same tap? Because it is closed and sealed, we think that it is pure. This is the effect of applied science. Blindly, please understand, blindly, without questioning. Jignasu means what? Jignasu means one who is inquisitive. That is the nearest English word that I can find it. Inquisitive means what? Why? Who? What? When? These are all the question marks. One should put it to himself and also to the rest of the world and start questioning. Beauty of this particular code, Hindu code, the way of the life in Hindu law is that you can even question the God. Athato Brahma Jignasa Om. Whether the God exists, put a question to yourself. I will give you the what are all your doubts, and I also give you the solutions for your doubts, the answers. You deduce by yourself. Morning, Krishnan was telling, it will automatically deduce and give it in the form of the reason. Even today, the Supreme Court ruling would say, reasoning is the heartbeat of the judgment, and one should not decide the case initially. You go on substituting the facts by reasons. Ultimately, reason should ultimately end in that this fellow is guilty or not guilty. That's all. This fellow is entitled to have a decree, not decree. This document in dispute is signed by him or not signed by him. You should not say it has been signed by him. Somehow I want to say that he signed by him, signed by him. Your judgment is an absurd. That is what the scientific analysis that Mitakshara on Yagnavalka made. He gives the meaning of Sapinda based on the Garbhopanishad, and he says, A new fetus, Shukra Shoni Samyogaha. Shukra is sperm, Shoni is ovary. Shukra Shoni Samyogaha. You know the modern science that a sperm, lakhs of it will be there. One among the whichever is the predominant, will be in a position to reach up to the ovary and then gets into it inside that particular ovary, and then a ball is formed. A small ball is formed. That is called fetus. Now this ball will grow and grow, and ultimately one would get a double heartbeat here. Then the pregnancy test would be positive. Yes, as simple as that. Now this Sukra Shoni Samyoga, when it takes place, it has got the chromosomes. As all you know, there is a 26, 28 chromosomes that are there to form. Among them, if it is XX, ultimately all the chromosomes, it is a female baby. If it is XY, the last one, then it is a male. So nobody should blame any female for getting a female child. It is you, it is me, it is the male who is going to decide. Please understand. If the male chromosome in the form of the sperm does not have that Y, one pair making into XY, you can't help it, it is the female. We have a text called Sartha Shodasha Samskara. I don't dwell upon that further. Where by the biotechnology in the library, that what it can do today, a samskara was made at the 13th week, at the 12th week to the 14th week, where this could be altered male into female. This is called Pumsavana Kriya. I will not deal with that now for the purpose of our lecture. We shall forget. That's how you will get, Putra Kameshti Yaga, Dasharatha and his 3 wives eating the payasam and getting 4 male children. Look at it, what cock and bull story. No, it was possible. That was what was, we knew this method. Puru Aila, that comes in the Purana, person will turn half into the male and half into the female. Now we have what is called transgender. Wife wanted a daughter, husband wanted a son. While giving the Abhimantrita Payasam, there were 2 mantras being told. So he had the dual character. It's a separate science for the biotechnology. When I rendered a lecture for biotechnology people with the Hindu Dharma Shastra, this was a very beautiful point for discussion, and it is being discussed even now. Let us now forget that and say, Asti, the skeleton portion in that chromosome, in a small portion which is not visible to eye. Sir, please understand. It is not visible to common naked eye. That is visible only with the electronic microscope. That chromosome, when it predominantly takes shape, in that chromosome, the progeny, the skeleton portion in a minuscule form comes from the father. The muscles come from the father. Blood comes from the mother. Other organs come from the mother. This is told in Garbhopanishad. Vijnaneshwara had profound knowledge on these aspects of the matter. From that angle, he says, Sapinda is one who shares the blood. Sir, please understand. Science is so advanced. We are in 21st century. We are in a position to prepare a sheep in the laboratory. England people have succeeded in making it, cloning. They are unable. Why England? Americans, entire world, they are unable to prepare a drop of blood. We have disintegrated blood into the several portions. We say platelets. When somebody is suffering from dengue, we say platelet count. We have gone up to that extent. We disintegrate blood into several portions, remove RBC, remove WBC, remove platelets. All that we have done. So you mix all that and then get a drop of blood for me? No, sir. Not possible. Till today we are not in a position to do. But that is the gift of the God. Irrespective of he is a Muslim, Christian, Parsi, Indian, American, any other for that matter. Gift of the God. Nature has given that. Now from there, he says, try to explain what is a sapinda. See, where is 10th, 11th century, 1000 years earlier, when nothing was known to the rest of the world, even the other commentators failed and they only said pinda means a rice ball. This man explained, she whose pinda or body is samana is in common, is called sapinda. Who is not sapinda is an asapinda. Such a one he should marry. So you should marry a person who does not share the common blood group. End of it, sir. Why means when he gets the progeny, there should not be any deformity. Marrying the niece very much available even in some portions of the Tamil Nadu today, in some portions of Karnataka which has got Tamil Nadu influence, and some portions of the North India, because wealth should remain in that family. Even in some portions of Andhra Pradesh, it was not there in a particular community. I have got 5 kg gold with me. If I give my daughter to my own brother, that 5 kg, this 5 kg, 10 kg will remain. And the progeny is like this. Deformity. What to do with the 10 kg then? Ask anybody, ask any neurologist, he says, did you marry your own relative? Yes. This is the problem. This is scientifically possible because the genes will not grow further because NPN, combination, permutations and combination mathematics, we have all studied in 8th standard, where that P plant is given, last plant will be a dwarf one. Santatik Shinaha. Please understand. Santatik Shinaha. What will happen? The deformity takes place in the genes. There is no next set of chromosomes made into in the form of that sperm, because that sperm is also utpatti is from the blood alone. Which blood you shared? You shared the blood of your father and mother. This is what he says, in common. Thus the son stands in sapinda relationship with his father, because the particles of his father's body having entered his body. In the like manner, stands the grandson sapinda to relationship is his paternal grandfather, and so also maternal grandfather. This is where the Vijnaneshwara trims by himself. How beautifully he expounded this particular proposition. 1000 years later, when we analyze with the modern techniques that we have, beautifully expounded by giving the interpretation, by taking the advantage of Mimamsa. My dear friends, Mimamsa is a text which is required to interpret the Vedic rites. Now, that text he uses it for the purpose of explaining the factual aspect, alaukika, that is the vyavaharika, not related to anything to God. I'll tell you, if somebody has read the Mimamsa, Maxwell rule of interpretation looks very primitive, sir. Very primitive. Asking the fellow who has run the 100 meters race in 10 seconds and a fellow who has completed in 1 hour, coming and telling how difficult to run 100 meters in 1 hour. Fellow has completed in 10 seconds. In Kannada, there is a proverb. Hattettolge vandhettol helkotlu anta. Means to say, a mother who has delivered 10 babies is being taught by a mother who has first delivered his first baby. What is the labor pain? So this is where we are in. And all these things were assumed in the mind. And a theory was developed by Vijnaneshwara, calling that sapinda relationship is this, not the one who gives the rice ball and takes away the property. No, that should not be the interpretation. So also the nephew of a sapinda relationship is maternal. He goes to the extent of co-sisters, Neganni, Orgitti, co-sisters. He asked him why. Co-sisters, he says, the brother and his younger brother or elder brother has got the blood particles from his mother, and that blood particles is in the Shukrashroni Samyoga with the newly having the wife, a separate one wife. It is as simple as this to understand. Bhumi onde, bija badalu. The mother earth is the same. What you sow, what you reap. Whether it is this earth which is deciding, or the seed that you are sowing in. Very simple. Brinjal will come. If you sow ladies finger, ladies will come. What happened to the earth quantity, earth quality? It is one and the same. Right? So this particular portion was explained scientifically and said, male DNA, when you want to give the property, it is for the in the form of agnates. That scientific example was accepted by the world across the country. India as today is not the India then. We went up to Turkey. We don't have the studies now whether what was being followed there. Some researchers made, they have accepted. Afghanistan, Kandahar, the earlier Gandhara is the Kandahar now. Those who are interested may make a study there. Also for our purposes, except the West Bengal, Assam and portions of Bihar, where Daya Bhaga, it is not, no. Daya is again a word that has been interpreted by Vignaneshwara in a different manner. Therefore, he goes different, makes it from the Jimutavahana. Let us not worry about that in regard to the time constraint. So this study that he made, and therefore said, if you are marrying your own cousin sister, it is equivalent to sister because that blood continues there. You can't have a relationship there. What is happening today? Therefore, we say, Attige Devara Samana. Attige is elder brother's wife. She is made as equivalent to the goddess because in a joint family, when the mother is there no more, or when mother is having some other difficulty, this eldest daughter-in-law is to take the place of the mother of those younger brothers of the husband and used to bathe them with oil on their head. And you know, when you want to bathe, you will be having the shortest possible cloth on your body. She should not get attracted to him, or he should not get attracted to her. How do you now control it? Controlling it is, you give the Shastraic sanction that she is not. Then it's the matter. If you want to have relationship with your mother, you can also have relationship with me. If the Attige used to say that in that fashion, which Maidana will do that? As simple as that. My dear friends, the sex is not in between the thighs. It is in the eyes. It is in the mind. Dirty mind. So train the mind in such a way by Shastraic sanction. She is Sapinda Sagotra, sister. There ends the matter. Even if you want to touch her, it is with love. That love is different from a lover whom you want to marry. As simple as that. See what a scientific interpretation that he has given, and then carves out the right for the Sapindas, and then says this lineal descendancy was with the male because it is the sperm which is going to decide the next progeny. Yes, from the angle of now, looking at the Article 12, Article 13 that the state is not required to make any law which is gender discrimination, Article 14 with the Constitution, what we have today, this looks absurd. But in the absence of Constitution, which was better? One who offers the rice ball, or one has got this lineal descendants? Decide yourself. Decide yourself. In the absence of Constitution, for a moment, let us understand, if you want to decide this case in 1946, what is your answer? One who offers the rice ball or one who is born to you? That is where he carves out the right for the females also. This morning I said, Honorable Justice Nazir Saab told me that Srisha, you have got a challenge. I am prepared to take the challenge. Why he says is, while giving the interpretation to the word called Dauhitra, Vijnaneshwara is the one person who could say, how can you deny your own daughter than a person who is an outsider? Please give them also. Because if not that Y chromosomes, he has got all other X with you. The daughters have got all other X with them. Why should you deny? So he says, daughters are also entitled. It is not 2005 amendment. Friends, it is not 2005 amendment. This right was very much there. Then who toppled it? It is the several invasions. It is the Britishers. They came, they wanted to expand their empire. So they came with a law, Dattu Makkalige Hakkilla. Adopted son has no right. Then daughters no right. Entire Rajya is yours. You take. Now you see who altered. And who are the responsible for it? It is we, because world is suffering from silence of many, not by violence of many. Not by violence of many. These dirty people who want to meddle with our system are few in number. If all of us are united, we can tame them within no time. But what is doing? इनका problem है, हमारा क्या? It is his problem. Why should I worry? Friends, what the rule of law would say? Injustice somewhere is injustice everywhere. That is the law. If it can happen to him, it can happen to anybody. What is the test of ultra virus of a provision of law that the present day we are doing it? 500 and odd MPs in Lok Sabha and then Rajya Sabha passing the bill, then President giving the concurrence, become the law. One next, anybody in this particular hall can become the petitioner and test it before me. Sir, this is going to violate my rights in this fashion. Gone, it is held as ultra virus. So then who is suffering? Why world is suffering? This courage we did not show it at that point of time. We did not want the beautiful food plate of meals that we had. We were attracted to 2 minutes Maggie. That is the reason we have lost this and that also. Anatho Daiva Rakshaka. What a beautiful saying. You will see in CPC. If there is no guardian, we appoint who is called court guardian. Now in Kali Yuga, when we have no Raja, we have only the court. So Anatho Daiva Rakshakaha should be now understood as Anatho Nyayalaya Rakshakaha. I am saying Nyayalaya Rakshakaha. When you split the word Nyaya Laya, no, Nyayalaya. Laya means losing, diminishing, losing. So Nyayalaya Rakshakaha. So we appoint all these people. This is where Vijnaneshwara stands from the other commentators in a higher pedestal. Now coming back to the inheritance and succession. So Mitakshara actually, when somebody looks at the meaning in the dictionary, in the Sanskrit dictionary, the nearest word that I could find out, the synonym in English is, it is reflection of oneself. Why Vijnaneshwara gave the commentary the title as Mitakshara is, he says, have an introspection yourself about your soul. Please look at it, what a scientific way of even giving the title. Have an introspection of your soul. By this interpretation, if you can accept that this is the proper and correct interpretation, well, you can have that, hang on to it, no problem. If it occurs to you that it is injustice, please correct it. Therefore, I name the commentary as Mitakshara, which means a reflection of one's mind. This is what at another aspect. And then I will not touch upon the other important aspects, namely by birth, why it has happened. I have explained scientifically the reasons. The school, now we are calling at Mitakshara school. Why it should be called as a school? What is the meaning of a school? What is the meaning of a school? I give a simple example. Now, this is the blue, right? Everybody would say, this is the blue. Who said that this is blue? Anybody? Anybody can say. Sorry? Who said that? I would call it as green. No, red. Something red. Something red. I have green here. Anything red. Sorry? What is this? Color. Red. Agreed. And what is this? Green. Sir, I am telling you this is red, this is green. Why? 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 Please answer me. Who is the society? Who is the society? Teacher. Yes, this is the answer. You go back to your first standard. A chart was put and the teacher said this is green, this is red, and gave a box full of articles, some toys, everything. Then teacher asked you to pick up the red one and green one. For a student like me, in the box there was no red, no green. What should I do? So I cried, Madam, I did not get any. Madam called, he is the honest and brave boy. Because he could not either locate the green or red because it is not there. Loyalty, honesty, integrity is either black or white. No gray in that, sir. Sorry, no gray. Hope you are been able to make the difference. If the teacher has taught that this is the green and this is the red in a school, and he becomes the station master in a railway station, what is the result? So now you are in a position to understand the interpretation and the meaning. So my endeavor was not to test you with the colors. This true interpretation, if you don't reflect with your interpretation of the law, absurd results are going to happen. That is where Vijnaneshwara also got a separate and distinct place, and therefore his thoughts were easy to be assimilated because it was acceptable to the society at large by passing the objectivity test. Please understand this. The modern jurisprudence wants it objectivity test to be passed. I put 4 bottles, glass bottles, transparent. In one bottle, I put salt. In next bottle, I put the sugar powder. In the next bottle, I would put it the limestone powder. In the last bottle, I put the rice flour. Right? I have not labeled it. I ask any one of you to come with a blindfold and taste each bottle and show your reaction, and your partner should say what you have eaten. Right? Is that simple? Everybody has followed. So person who eats the sugar powder will say, and the person who has taken the next bottle with salt would say, I want some water. The person who has eaten the rice flour and one who eats the lime powder, piece of chalk, it is powder and kept it, he would say, why? Your tongue knows the truth, no? This, everybody, whoever eats this, will have the same reaction. This is called test of objectivity. I have made it very simple. So, your judgment, when read by 100 people, if 99 were to say this is a good judgment, test of objectivity is passed. And if your judgment is read by 100 people and 99 would say, this fellow has got kidney in the place of brain, then that's also objectivity test only. So, what are the people who are not decisive? They are unable to say it is good or bad. Such people are called subjective people. Now you understand. For me, whatever I have written is the correct. This is the subjective satisfaction. We have no place in law for such people. Bahujana hitaya, bahujana sukhaya. The line runs in that fashion. Vijnaneshwara gave each shloka this meaning which has passed the objective test given the timeline. This is the take home from my lecture. I have got other examples as well. Sometime later, when we meet again, when we discuss Vijnaneshwara at length, when we discuss further aspects of the Vijnaneshwara, try to understand and improve our self, improve our soul, attain the moksha, attain the requirement, attain that sadgati, attain what you want, in properly understanding the meaning of a particular smriti and then applying it. Now the last question is whether it is relevant as on today. If we simply followed the Vijnaneshwara long back, there was no necessity to have an amendment in 1956. My dear friends, while on doing it with the Article 1314 in the Constitution, the framers of legislation took into its arena and only codified the Hindu law into 4 pieces. This country is a secular country. Why did you not attempt to do it for the Christians? Why did you not attempt to do it for the Muslims, Parsis? Are you afraid of voting? I don't know. Are you afraid of any other thing? I don't know. And we, majority Hindus, kept quiet. Silence of many, violence of few, resulting in chaos. So, Vijnaneshwara could have come to your aid when you attempted to cut into 4 pieces the codified Hindu law. Mind you, friends, we did not call any one of these Smritis as Hindu law. Sorry, we did not call. Because we believed in what is called Vasudhaiva Kutumbakam. What is Dharma then? It was a code of conduct. How you go? Today you see the median in every road, toll roads, median. People have tread on these roads even when there was no median. Then how are they making it? Single road, number of accidents were less. Double road with median, accidents are more. You must have seen in the paper the Mysore Expressway. Accidents are more. Why? The important aspect with the Vijnaneshwara gave, the samyama, patience, the first quality, is not there. Let the other man pass, then I will pass. What is in that? It's a split second. No, I want to pass. He also wants to. I put the headlight first. He also put the headlight. I said, go like this. He said, go like this. Both of them gone there. Bahujana hitaya, bahujana sukhaya, not objective test did not pass. So, Vijnaneshwara has got relevance even today if it is properly applied with the required modification to pass the objective test as per the constitutional requirements. I have taken 4 times the oath, sir. One as a lawyer to uphold the constitution and laws, one when I became a district judge, one again when I became the additional judge of the High Court, one again when I became the permanent judge, and that too from the governor. How can I violate now that? So I am clearly conscious of my duty as a judge. Yes, whenever I render a judgment, it would be in accordance with law, in accordance with the constitution. There cannot be any doubt about that. But I am an individual, sir. I can have my random free thoughts to be propagated in a august audience like this and then see where were we and where are we. It's a question to be pondered over. Hope the session number 1 which concentrated more on the practical aspects and then gave you the insight into the subject thoroughly, how beautiful our system was, and what happened when we gave up that system in comparison with the system that we are already having it with a huge crores, 5 crores of arrears of cases to be decided, and according to one MBA fellow, it takes 350 years. So it is not going to be decided in your lifetime or my lifetime. So we should not bother and allow it to be becoming much older. Or we want to find some method, some way where we can improve ourselves, having a Mitakshara onto ourselves, a reflection onto ourselves with the applied science at our command. And should we not accept the best practices which were there and suggest, because it's a central university, Vice Chancellor is there, he has been keen enough to be there in technical session as well. He has assimilated the cream out of it. The lecturers are here, trustees here, responsible persons are here. You are all citizens of the country. You are all independent of the requirements of the law which is there, which is now we are following. Suggest some good amendments to the existing law, which I can't do it because I am only a judge, and then say whether it is right or wrong. You are the persons who can bell the cat and then say this is where we are going to have it, and arrive at such a beautiful mechanism where our children, our progeny further, the santati that is going to come, can bring back that glory of this nation back again with all full flourishing manner. And I see a beautiful Bharata Varsha again, a beautiful Bharatiya jurisprudence again, a beautiful law which is required for the men of this country at large are wanting, and not the obsolete law which was imposed on us by the Britishers when we are not having any voice to raise. Now that we have, it is 75th year we have completed. In the light of 76th independence, should we not venture for that independence and suggest some modifications with scientific analysis that what we have decided, and tell the peoples, lawmakers, to make out, yes sir, this is what ultimately we want. This is how our children are to be there. It is the job of the young lawyers, budding lawyers who are coming, researchers who are there, the faculty who are here. One and all, Vivekananda has said, Swami Vivekananda says that every soul is born divine. One must work towards divinity. Means each one of us are capable of doing it. Why can't anybody stand different like Vijnaneshwara and say, sir, this is what I want for the Bharatiya jurisprudence angle. This is where we are suffering because we have given up the best practices. And if that any such thing that has come out as the cream of the theme of the subject today, I think I'm a selfish fellow, sir. I'm a very selfish fellow. My 3 hours, 4 hours spending here and my traveling to Kalburgi, back to Bangalore, it won't come back in my lifetime again. And I deem it that it is a amount that I have, premium that I have paid in my life. It's a premium that I have paid in my life, because my time won't come back. Maybe I get some good applause here. You will remember for 2 days. It is having about 1,000 views in YouTube. Fine, all that is satisfaction. I'm not satisfied. I want dividend back. In what form? The churning process has resulted in the nectar here. That nectar should reach the concern, and we have a Bharatiya jurisprudence triumphing again by making necessary amendments there. That is the best dividend I can get back in my life. Before I conclude, I would like to say, Yadrochate tad grashyam yanarochate tad tyajyam sukhena bhoktavyam. Again, you see, now 3 Sanskrit. Nobody is in a position to understand. Let us spend time. Yadrochate tad grashyam. What little that I could make out, what little effort that I have made among my other work, your time, my time spent here. You are having the right to accept whatever is acceptable to you. Yadrochate tad grahyam. Whatever is acceptable to you, you are having the right to accept it. Yannarochate tatyajam. In my thought, in my way of expressing the Vijnaneshwara, in my anxiety to say how beautiful the Vijnaneshwara is there, if any one of the single soul here is not in a position to accept a piece of the lecture that we have done or in whole, they are entitled to reject it in toto. That right you have. Ennarochate tatyajam. Sukhena bhoktavyam. But if you have accepted what is that you wanted, even one sentence, one word, pratyaksharam pratipadam, if you have accepted one letter, one word, one sentence, or the entire lecture, you should enjoy it, propagate. You should enjoy it and propagate. The convocation address that was there in this country, not preparing a English speech, quoting the only foreign language, foreign authors and foreign thinkers as if it is a gospel truth, is not the convocation address our children want. Chancellor, Vice Chancellor Saab, such is not the convocation address. Yes, that is required, we do it, printed, coming here reading. After the convocation address is over, everybody will act in a different manner. You know how they act. What was the convocation address we had? After having the 14 years of the teaching in Gurukula, what is it that they had? After finishing the Gurukula, the Shishyas will be departing from that place, that bondage, very with heavy hearts. Everybody would be going, and some of them would be saying, Sir, if I have any doubt, I'll come back to you. This happens nowadays also. After getting the PhD, he says to his professor, guide, Sir, I'm going to the world back after the PhD. Still, if I have some doubt, I'll come back to you. After getting the PhD, what is doubt that I have? Anyway, Guru would say, you are always free to come back to me, my dear. You can come back. With that heavy heart, when they were leaving the convocation address in the Shikshavali Brodaranyaka, it is said, I have taught you what are all the virtues. Basics he was talking. Sharma also finding it on the basics. You should not leave the basics. Dharmat na pramaditavyam, kushalat na pramaditavyam, bhutyai na pramaditavyam, swadhyaya pravachanabhyam na pramaditavyam. What a beautiful way of giving the convocation address. I have taught you everything. Don't give up the dharma. Don't give up the satya. Come what may. Don't give up these basics. If you are going in a speed limit on the left side of the road, even if the other man comes very fast and rational, in a rash and negligent manner, stop your vehicle, he will pass off. Why are you going against that fellow? Dharmat na pramaditavyam kushala. Pakistan had some natural calamities. We have a day, everyday war. People at Siachen working out, protecting our country. We have lost our Jawan's life there. Natural calamity. Prime Minister office immediately said, send them food, send them medicine. Sri Lanka, they created problems. We sent the food for them. Any other country across, we sent the food. Our call was the first to take it. Later on, Pakistan people said those people rejected who wanted it. Kushalat na pramaditam. If you say you are good, I am good, and my good is your good, there ends the matter. Bhutyai na pramaditam. I have something excess. Fellow doesn't have that today. Basavana said, Kayaka, dudime. Kayaka is what to do. Karma. Kuru bhungshvacha karma nijam niyatam. Haripada vinam radhiya sadhanam. Madhvacharya. You should do the work and then earn it. That excess, when it goes for that, somebody is not having it. You wait for that particular person on that day. You offer him. If you offer that fellow who has not been able to get it on that day, that becomes dasoha in Basavana's words. If everybody is fed by the God on that day wonderfully, protected, offer it to the birds and animals, dog, a crow, a sparrow, offer it. And whatever is remaining is prasada. not preparing with a full ghee, with dressed with cardamom and then grapes and cashew and eating it. No, that is not the prasada. Prasada is after getting the money in kayaka and then offering it for the dasoha and remaining is prasada. This is what has been said in Kushalat Bhutyaina Pramaditavya. Then last one is Swadhyaya Pravachanabhyam Na Pramaditavya. For the sake of this seminar, with the scientific angle, applied science, I had to revisit to the Yajnavalkya and Vijnaneshwara. I had to take back the book that was written by my professor, reread it again and again, and understand how it could be applied. And that is the Swadhyaya, I did it. The cream thereof should not lie with me and die with me. So, pravachanabhyam na pramaditavya. I come here to share with you that knowledge. These are all, if you do it, then the world will not suffer with any of the ill wills, is what the convocation address that the Shikshavali has given to us. In contrast with what the convocation address we are having, everybody should compete, you while so competing, you cut your friend's legs so that he cannot run the race. No, let us run the race together. You may become first, I may become first. We'll share the joy. More than sharing the joy, we will share the sorrow if need be. I am there with you, my friend, in your difficult times. For sharing the happiness, everybody will come. For sharing the sorrow, only few people who are of virtue can come. That virtues can be brought in only after studying Smritis in a proper scientific manner and assimilating it. With these words, I would conclude. Thank you, one and all.
Thank you, sir. The session was absolutely fruitful. And what your lordship said in the inaugural session and this session was exactly right. And it's our duty. We want to take over what our forefathers handed over to us. Now, now I request Sri M.D. Nargun, Senior Advocate, to take over this session.
There is a one proverb. Once wonderful judgment is being rendered, the next judge is concluding the judgment with only two words. I agree. Therefore, friends, I don't want to give any presidential address. We have enjoyed a wonderful food for thought. I agree with the message which my Lord Justice Sri Sananda has given to us. And immediately after this, we have got one more good food. Justice Indiresh is here. Let us enjoy the next session. Thank you all. Thank you, organizers. And for the benefit of students, my article is being sent to you in a WhatsApp, in the messages, in a YouTube or something, in the particular soft copies. Please go through it. Number of references are there. I request you to read. Thank you. Thank you all.
I really thank you to Sri M.P. Nargun, Senior Advocate, High Court of Karnataka, and former Additional Solicitor General of India. I convey the gratitude on behalf of Department of Law. Now, I would like to call Vasundhara, Assistant Professor, Raichur Law College, for a paper presentation.
Namaste, one and all present over here. Actually, I, being the faculty of Hindu law, just I am very much thankful to sir. Really, today, Sapinda and the prohibited degree of relations, after that long discussion, Honorable Justice, there is no word to express. I am very thankful to you, sir. Uh, Today, just I had given the 4 minutes for the presentation because just I am reminding the, since from morning we are hearing the Mitakshara and Vijnaneshwara. Sir, I'd given the some that's a thought that if you want the 2 minutes Maggie, choice is yours, and if you want the full meals, and you should study each and every words that is a very weightage, and we have to carry, and also we Krishnans sir also mentioned that everything in the our ancient that is a scripts unless and until we involve and take it we cannot that is a find the solution and moreover that is one more that is a resource person very well expressed that because that we have to ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ತೇವೆ ಏನಂದ್ರೆ ಋಣವನ್ನು ತೀರಿಸಬೇಕು ಅಂತ ಹೇಳಿದ್ರು ಸರ್ ಆಕ್ಚುಲಿ ಈ ಗ್ರೇಟ್ ಸೋಲ್ ಜಸ್ಟಿಸ್ ಆನರೇಬಲ್ ರಾಮ ಜೋಯಿಸ್ರವರು ಇವತ್ತು ಜೀವಂತವಾಗಿರೋದಕ್ಕೆ ಅವರ ಒಂದು ಸೇವೆನೇ ಕಾರಣ ಅಂತ ಅನ್ಕೊಳ್ತಾ ಇದ್ದೀವಿ ಜಸ್ಟ್ ಐ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಮಚ್ ಟೈಮ್ ಬಿಕಾಸ್ ನರ್ಗುನ್ ಸರ್ ಟೋಲ್ಡ್ ಇಫ್ ದ ಪರ್ಫೆಕ್ಟ್ ಡೆಲಿವರಿ ಆಫ್ ದ ಸೆಷನ್ ದರ್ ಇಸ್ ನೋ ವರ್ಡ್ಸ್ ಮೈ ಟಾಪಿಕ್ ಈಸ್ ಆನ್ ಧರ್ಮ that is dharma just next slide only one slide you skip that I have the Raja Dharma book with me that is written by Rama Joyce sir that is a dharma means as sir told when we understood the concept thoroughly there is no conflict ಸರಿಯಾಗಿ ನಾವು ಕಾನ್ಸೆಪ್ಟ್ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಾರ್ದೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಧರ್ಮ ಮೀನ್ಸ್ ದಟ್ ಈಸ್ ವಾಟ್ ಯು ಸೆಡ್ Justice Rama Joyce, Dharma is that which sustain and ensure the what you call uphold the what you call the prosperity of the people. Therefore, my suggestion, because I have the several slides, no need because already we have the what you call the wonderful session here. My suggestion is that because it's not enough to have the discussion in the national seminars, but we have to carry over. As Justice told, ಬರೀ ನಾವು ಈ ಸೆಷನ್ನಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಮಾಡೋದಷ್ಟೇ ಅಲ್ಲ ಆಸ್ ದೇ ಆಲ್ಸೋ ಸಜೆಸ್ಟೆಡ್ ಟು ದ ವೈಸ್ ಚಾನ್ಸಲರ್ ವಿ ಹ್ಯಾವ್ ಟು ಅಮೆಂಡ್ ದ ಸರ್ಟನ್ ವೆನ್ ಎವರ್ ವಿ ಆರ್ ಟೀಚಿಂಗ್ ದ ಲಾ ನಮಗೂ ಅನಿಸ್ತಾ ಇರ್ತದೆ ಎಷ್ಟು ಔಟ್ಡೇಟೆಡ್ ಲಾಸ್ಗಳನ್ನು ನಾವು ಕಲಿಸ್ತಾ ಇದ್ದೀವಿ ಅಂತ ರಿಯಲಿ ವಿ ನೀಡ್ ದಟ್ ಇಟ್ ಶುಡ್ ಬಿ ಅಮೆಂಡೆಡ್ ಜಸ್ಟ್ ಥ್ಯಾಂಕ್ ಯು ಅನಣ್ಣ
Thank you so much, ma'am. Now we are going to conclude the technical session 2 of our one-day national conference on Mitakshara, the applied science of Bharatiya jurisprudence. And for giving us a lot of knowledge, I would like to thank Justice V. Srishananda, Judge High Court of Karnataka, for sharing a lot of knowledge. His selfless attitude given us a lot of knowledge. This is the second time he is coming and sharing knowledge to our department. I also like to thank Shri M.B. Nargun, Senior Advocate, High Court of Karnataka, to coming to the session and giving us a message. And I would like to thank Professor Dr. Battu Satyanarayana, Vice Chancellor, Central University of Karnataka, for being here and attending the session. I would like to thank all the faculty members, faculties from other departments, deans of schools, PhD scholars, advocates and practicing lawyers, and my dear friends, everyone who attended this session. A warm thank you to all who all attended this session. Thank you. And after 2 minutes, we will go for the valedictory session.
Thank you, Adin. And now it's time to have a valedictory event. For this valedictory, yes, yeah. For this valedictory session, we have amongst us Honorable Justice Shri E.S. Indresh, Judge High Court of Karnataka. I request Honorable Justice E.S. Indresh to come onto the dais. I also request Honorable Vice Chancellor, Professor Bhattu Satyanarayana. I also request the guest of honor, Sri Suresh D. Bulbule, to come and occupy the chair on the dais. I also invite Basaraj Hoopkaddi. I also invite Dr. Renuka Gubewad and the trustee of Vijnaneshwara Pratishtana, Senior Consul Sri Amit Deshpande on the dais. Indeed, it was a very fruitful day since morning. Now I request Dr. Basavaraj Hoopkaddi, the Dean, School of Law, to welcome and introduce guests to the audience.
Good evening to you all. We are in the last part of the conference, that is valedictory. Already we are getting late. In this valedictory session, we have a chief guest, Honorable Justice E.S. Indiresh, Judge High Court of Karnataka, as a chief guest. On behalf of the Department of Law, Central University of Karnataka, I welcome you, sir, to this August gathering. Justice E.S. Indiresh has completed his LLB from the Sharda Villas College of Mysore, and then he has completed his LLM from the University of Mysore. Sir secured first rank in the LLM, and then he enrolled as an advocate in the Karnataka State Bar Council in the year 1996. Sir joined the office of Srimati B.V. Nagaratna, who is the Honorable Justice in the Supreme Court. Sir was guided by the eminent persons like Madam. And Sir served as a government pleader and then additional government advocate in between 2009 till the elevation to the High Court. Sir has elevated as a judge of Karnataka High Court in the year 2020, and then as a permanent judge in the year 2021. Once again, I welcome you, sir, to this valedictory session. I also extend my warm welcome to our Honorable Vice Chancellor, Professor Bhattu Satyanarayana, to this valedictory session. I welcome you, sir. I extend my warm welcome to Sri Suresh Bulbule, Chairman of Hingulambika Institutions Kalaburgi and also Trustee of Vijnaneshwara Pratishtana Trust. I extend my welcome to Sri Amit Kumar Deshpande, Senior Advocate, High Court of Karnataka and a Trustee Vijnaneshwara Pratishtana Trust. I welcome Dr. Renuka Gubewad, Assistant Professor and a Coordinator of the program. I welcome all the dignitaries, all the participants and all the staff members from other colleges and also the staff members of this institution. I welcome one and all. Thank you.
Thank you, Dr. Basavaraj Hoopkaddi. Now I request Honorable Vice Chancellor, Professor Bhattu Satyanarayan sir, to felicitate today's chief guest, Honorable Shri Justice E.S. Indiresh. Similarly, I request Honorable Vice Chancellor Professor Bhattu Satyanarayan sir, to felicitate today's guest of honor, Sri Suresh Bulbuli. Thank you, sir. Now I request and invite today's chief guest, Honorable Sri Justice E.S. Indresh, Judge High Court of Karnataka, to deliver valedictory address.
ಎಲ್ಲರಿಗೂ ನನ್ನ ನಮಸ್ಕಾರ. Learned dignitaries on the dais, Brother Justice Shishananda, learned senior advocates, students, invitees, and public electronic and print media. Of course, it's a valedictory. Valedictory means nothing but, for a law student, a preamble to the Constitution. Because the preamble, if you read the preamble, you can see what is there in the Indian Constitution. So far as the topic today, since morning you had an opportunity of hearing Learned Brother Justice Shishananda and learned professors, and it is nothing but getting knowledge about what our forefathers did for us. Because this is a period where between 8th century to 12th century in India, though we have been insofar as we have seen many great commentators. And further, during this period, if you see the doctrines have been evolved. That was, we can see even in Justice Yendre's Sikri's judgment in Keshwananda Bharati also. But of course, in this period, these great thinkers like Vignaneshwara or Chimutavana or whoever, they have a kind of reflective thing in their mind. The student of law must have that insofar as reflective thinking. What is meant by reflective thinking? It's very difficult to define what is reflective thinking, but it could be explained. How it could be explained? So all of us have to take for an example. All of us we have seen joke falls. So if anyone looks at joke falls, everyone will be very happy. When Mahatma Gandhiji went there, being a great patriot of our country, he said, "I am so luckiest person. I'm so blessed that I'm born in this country because I could be able to see nature." Likewise, K.S. Nisar Ahmad went there. Jogada Siri Belakinali, Tungiyatane Belakinali. Because being a poet, is written in a very great poetry. Even today, everyone remembers. And we are also seeing joke falls, and along with our wife, children, sisters, brothers, friends, and we are also happy. But when Sarva Vishweshwarya went there, he said, "Don't waste water. Please generate hydroelectricity." Because he's an engineer. See, all of us have seen the very same object, but our perspective on the very same object is different from personality. Because of this, take for example, though insofar as the person, those who are made a remarkable history in our country between 8th century to 12th century. They have got a they have a very great reflective thing in mind. With this, just I will begin insofar as my concluding remarks is concerned. Here, it gives me immense pleasure, Vice Chancellor Sir, and the Faculty of Law, to stand before you today discuss one of the most influential systems of law that has intricately woven itself into the fabric of Indian society. It is true that the state that there are ideals and rich tapestry of wisdom and justice that is encapsulated within the Mitakshara school of thought. It ought to be noticed that Mitakshara is not just a mere compilation of rules and statutes, but it is a philosophical and social system that has played a fundamental role in shaping the familial and societal structures of the regions where it prevailed, especially within the Hindu society. The Mitakshara school of thought is named after the seminal commentary written by Vijnaneshwara called Mitakshara on the code of Yajnavalkya, as you are aware. The influence of this commentary is such that it transformed the landscape of Hindu personal law jurisprudence, and its interpretation of law still resonates in modern legal database. This rich legal tradition is an active, breathing part of our society and is an emblem of the timeless wisdom that has withstood the test of time. It has since been codified under numerous acts, further dictates to frame rules around prosperity, property, inheritance, and family law, among other areas, and is thus worthy of our understanding and respect. Vijnaneshwara, an esteemed name in the annals of Indian legal history, was a preeminent jurist and scholar who lived around the late 11th and early 12th century AD. During the reign of Chalukya king Vikramaditya VI, Vijnaneshwara hails from Martur village, Kalburgi district, Karnataka, and the stone inscriptions of 1124 AD obtained from Kalingeshwara temple of Martur note that the Vijnaneshwara lived in the court of Chalukya Emperor Vikramaditya between 1076 to 1126 AD, and Mitakshara were accepted as an authoritative text on Hindu law due to its scholarship, logical analysis, and intellect of its author. It was told, when Emperor Vikramaditya read the treatise, he touched the feet of this great man. Salute to him. The inscription on a stone plaque found at Kalingeshwara temple in Martur village, it says that when Emperor Vikramaditya bent down to salute Vijnaneshwara, the emperor's jeweled crown touched the feet of Vigneshwara. The Mitakshara is an extensive and influential commentary on Yajnavalkya's Dharma Shastra. Because why I'm saying all these things insofar as law students is concerned, we have seen many interpretative techniques, whether it is a constitution law or any other statute to be interpreted. Normally, we used to see the Maxwell's or Vipasarthi, or insofar as the Triparty or whoever may be. But insofar interpretation is concerned, while interpreting any law, one which is existing but is not codified, normally one must look into the text and the context. You must see the text to in which context that you can interpret it. A particular provision. That's what even we can see in the Indian Constitution. What was equality yesterday may not become equality tomorrow. That's what we have seen. Because this is why I'm saying, though after the advent of the new Constitution, that is 1950, today's Constitution is not a new one for us. It was there even earlier. If you look at the Minto Marley the reforms, 1909, or Montego Chelmsford, or insofar as a Lahore session held in 1930, or 1935 Act, where we say that it is the conceived in the mind of the British people that they want to give freedom to our country, and thereafter Quit India movement, Cripps mission, and various till the formation of the Constituent Assembly. We can see today's constitution is not, we may not say that it is made by contributed by a founding fathers, but it is nothing but they experienced that what they had earlier they wanted to give to the next generation, because then we were only 33 crores when our constitution was made. That's why the great, insofar as the constitutional values or constitutional document is concerned, we must always remember the great jurist B.N. Rao. His contribution is very impeccable. But for him, today we are all living in this country. Otherwise, we would not have been. Because to say that absolute corrupts absolutely. That the area in which, insofar as he worked out, he met many people, what kind of the liberty we must have, personal life, or insofar as the various provision of the part 3, whether it may be the part 4 of the Indian Constitution to directive principles, or insofar as, because if you look at the Indian Constitution, we borrowed from the part 3 from the US, insofar as UK parliamentary system of government we have seen, and Irish Constitution we have seen the many aspects like this, the various aspects, even the national emergency 352 to 360 that we have got it from France, and trade and commerce from 301 to 38 deduced from the Australian Constitution. The insofar as the distribution of power in 245, 246, that we got it from the Canadian Constitution. If you look at the Peter Hawke's contribution to the Canadian Constitution, where we can see that how our Constitution has been made. Why I am saying all these things? We have this kind of people earlier, between 8th century to 12th century. And they have, insofar as already there was a rule. I cannot say that there was no rule. It was there, but it was not put into motion. Because today's where the Honorable Justice Shishananda said that. In fact, he has elaborately says the scientific way and what we have thought of earlier, it was in practice for innumerable. Because if you want to say that it's a custom, it must have 7. We call it as a rupasi. If any one person say that a particular what we are following, a practice is a custom, it must pass through 7 letters. That is rupasi, RUPACCC. Reasonable, unobstructed, peaceful, antiquity, constant, certain, and the last one is consistent. Rupasi, RUPACCC. If such be the case, what the people of this nature, Vigneshwara, in fact, he has given to us. If you look at insofar as in the form of the constitutional aspects, I would say, the Mitakshara is an extensive and influential commentary on Yajnavalkya's Dharmashastra. Mitakshara is written in the form of a metrical treatise, divided into several sections, encompassing various facets of law. His other work encompasses vast areas of law, particularly civil, criminal, procedural, and constitutional jurisprudence. But perhaps his most profound influence has been in shaping the laws around Hindu personal law, which is impeccable and laudable. It is through this significant work that Vigneshwara has left an indelible imprint on the evolution of Indian jurisprudence. It is considered to be a masterpiece in Indian jurisprudence, and it has stood not only the test of time, but also test of law. Because why I say, now we have passed through it 75 years. And from 1950 onwards, because if you look at, take for an example, even I was told like, though our, insofar as the Hindu Succession Act, Hindu Marriage Act, or the adoption and minorities, these are also act came into force in 1956 and 55, 56. But it was there in 1957. But what has happened? Because of the government doesn't want to give insofar as giving into effect. there is idea behind the rulers of our country is different. So Vignaneshwara is credited to be one who first propounded the concept of joint family property, as we have seen the principles of right by birth, established the rules of partition and co-personality. When India gained independence in 1947 and embarked on a journey to establish a new legal framework, lawmakers faced challenge of reconciling traditional laws with principles of justice, equality, and non-discrimination. This challenge was particularly evident while framing Hindu Succession Act 1956, which aimed to codify the laws relating to interstate amongst Hindus. The act drew upon Mitakshara's principles, particularly in areas related to co-personary rights and system of inheritance. As a result of the same, it can be said that Mitakshara's principles also indirectly influences marital sphere through its emphasis on joint family system and property rights. While the text influence on property rights and succession is well known, its views on law of gifts also have far-reaching implications. According to Mitakshara, a gift or dana in Sanskrit is defined as a gratuitous transfer of certain rights by the owner of subject matter to another person without any consideration in return. This was considered as an act of religious and moral merit and was often performed during religious ceremonies like festivals or during times of distress. When it comes to immovable property, Mitakshara law lay down stringent conditions. The text suggests that a man has full authority to give away his self-acquired property. However, when comes to ancestral property, such gift should be reasonable and must not deprive rights of other co-persons. A key characteristic of Mitakshara school in its context is its emphasis on the collective rights of joint family. The principle was critical to ensure that while individuals could perform meritorious acts through gifts, interests of joint family and rights of other members of joint family was preserved. It cannot be said that contribution of Vigneshwara and Mitakshara law merely had an impact solely on Hindu personal law. But also we see their contribution to public law has also been evident, and numerous components of commentary are considered to be part of essential constitutional notions today. Much like the constitutional head in today's democracies, the king as depicted in Mitakshara was expected to adhere to principles of fairness, justice, and rule of law. This is what we have seen in Manakaga, this case. Just as a constitutional head is guided by principles of constitutional values, king was guided by dharma. Moreover, the king was not considered above law. In Mitakshara interpretation of Yajnavalkya's text, the king himself was subjected to dharma, reflecting that there existed a principle that a ruler is always bound by the law. This bears a close resemblance to modern constitutional principle that no one, not even head of the state, was above law. This principle of commitment to the rule of law is a crucial link between the Mitakshara's depiction of a king and today's constitutional law. This, insofar as rule of law principle, you can see the A.V. Dicey's contribution insofar as the equality is concerned. A.V. Dicey is one who says that insofar as equality before law, first time. But in the constitution, we have incorporated not only equality before law, but also equal protection of law. Because not only before law we are all equal, even law also protects us equally. That is why insofar as the constitution, particularly the B.N. Rao said that, not only that we have to borrow what is there in the parliamentary system of government in UK related to equality before law, but insofar equal protection, even the state shall protect, even the law shall protect everyone. Because though there may be a Article 15, 16, which provides for various benefits for a class of people, but that is nothing but a doctrine of melting point, or what creamy layer, what we have seen after Indra Sani's case is concerned. In both the systems, rulers are expected to uphold justice, maintain societal order, protect citizens' rights, and are themselves subject to law. We must remember that Mitakshara, though written in a different era, under vastly different social and political conditions. Yet its core principles resonate with modern legal thought, serving as a testament to timeless wisdom encapsulated in this school of thought. The Mitakshara represents a vibrant intellectual tradition of ancient India, where scholars like Vijnaneshwara engaged in rational critical analysis of existing texts, using their wisdom to reform, redefine, and reinterpret laws to suit their social and temporal context. That's what I said. In some interpretation is concerned, one must look into the context in which a text has to be read. Their Lordships Justice Dr. M. Ramajois on 11/11/2007, while delivering lecture at Madhya Pradesh Judicial Academy, Jabalpur on the topic necessity of evolving a Swadeshi system of administration of justice. He said that, I quote, Bharata Ratna C. Subramanyam on Trivarga said in his book, CS speaks thus, India philosophy refers to Dharma, Artha and Kama as Trivarga principles. The inseparable group of three treats them as the warp and woof of ordered human society. Justice V.R. Krishna here in his foreword to his lordship said, my book Trivarga, as usuologically Trivarga in its immutable language thus, reject wealth, artha, and desires, kama, which are contrary to dharma, that is righteous code of conduct, namely ahimsa, that is non-violence, satya, truthfulness, asteya, not acquiring illegitimate wealth, Shaucham, purity, and Indriya Nigraha, that is control of senses, are in brief the common dharma for all the varnas in our Indian history. The trinity of fundamentals dharma, artha, kama, which constitute the constellation, is collectively expressed as Trivarga. The glorious epics, the Manusmriti, Kautilya's Arthashastra, and other classics governed the ruler and the ruled. Indeed, the rules of Dharma govern every sphere of activity, every profession, and every avocation. Insofar as the scope and meaning as also the role of Dharma in securing and preserving the right to happiness of all has been vividly explained by Justice K. Ramaswamy, speaking for the Supreme Court of India in his judgment in A.S. Narayana Dikshitar vs. AP, reported in 1969 SCC 548, has quoted his Lordship's view with approval. The concept of Dharma has been explained by his Lordships in his Legal Constitution History of India, Volume 1, at page 1 to 2, quoting the following, that is, Dharma sustains the society, Dharma maintains the social order, Dharma ensures well-being and progress of humanity. Dharma is surely that which fulfills these objects. Dharma embraces every type of righteous conduct, covering every aspect of life essential for the sustenance and welfare of the individual and the society. The word Dharma or Hindu Dharma denotes upholding, supporting, nourishing, that which upholds, nourishes, or supports the stability of the society, maintaining social order and general well-being and progress of mankind. Whatever the conduces to the fulfillment of these objects is Dharma, it is nothing but Hindu Dharma. Why I am saying all these things? Dear friends, insofar as the students are concerned, we have read in jurisprudence what the law is. The first one, insofar as positivism is concerned, is say that law is a command of sovereign. The next, insofar as interpretation, insofar as to define law, was Kelson's pure theory of law. You must have aware Kelson's pure theory of law. He said every law grand norm. Grand norm means nothing but in a pyramidal structure. Grand norm will be in the tip. That is what our constitution after enacting 1950. Insofar before 1950, what was there in Indian society? It's nothing but dharma. That is our nothing but a Kelson's pure theory. Because what we say that what we read insofar as the other text is concerned, whether it's a positivism or whether the law relating to the Kelson's or theory of law, or insofar as what we have seen in judicial review, It's for Marbury versus Edison in US. All these things were there in the Indian society itself. Put it in a proper way. See to that this is what we required for well-being of the society is concerned. The ideal that all should enjoy peace and happiness is implicit in this prayer. Om sarve bhavantu sukhina, sarve santu niramaya, sarve bhadrani pashyantu masayat. Let all the happy diseases, let all see auspicious things, and let nobody suffer from grief. In fact, it is there in his Lordship's book. ಎಲ್ಲರೂ ಸುಖವಾಗಿ ಬಾಳಲಿ, ಎಲ್ಲರೂ ಆರೋಗ್ಯವಂತರಾಗಲಿ, ಎಲ್ಲರೂ ಶುಭವನ್ನೇ ಕಾಣಲಿ, ಯಾರೂ ದುಃಖಿತರಾಗಲಿ. This was his Lordship said in his book. The universal has been the essence of our national life is evidenced by the fact that this sloka is inscribed in golden letters on the gate of Samsat Bhavan. The right to happiness is a compendious expression covering all specific human rights intended to secure happiness. That is why the ideal and slogan that is, let all people be happy, became an article of faith in our social and constitutional system comprising various specific human rights, the protection of which leads to happiness. This being a comprehensive human right merits to be included in the Universal Declaration of Human Rights of the United Nations on 10 December 1948. In addition to the same, Justice Markandeya Karju, former Judge Supreme Court of India, in his speech on 27/11/2010 at Banaras Hindu University, Varanasi, remarked about the ancient Indian jurisprudence, which reads, insofar as Mitakshara is concerned. He said that, I quote, in Mitakshara, however, Vijnaneshwara takes a wholly different approach. According to Vijnaneshwara, the word, in fact, Lordship's Srishananda would say in elaborating, the word pinda does not mean the rice cake offered in the funeral ceremony. It means the particles of the body of the deceased. In other words, inheritance is by nearness of blood or propinquity, and it has nothing to do with the right to give shraddha. This was a completely revolutionary approach. Really, it is a very revolutionary approach adopted by Vijnaneshwara, as it was a complete break from the traditional Hindu law view that the person who has the right to do shraddha has the right to inherit the property of the deceased. And it is a good example how law developed in India. Mitakshara is a much more secular, it is a secular law as compared to Daya Bhaga, since according to the Mitakshara, the right to inherit has nothing to do with the right to give shraddha. Thus, we see that by giving two different interpretations given to a single word, pinda, Hindu law got bifurcated into two different branches. The Mitakshara, as already stated above, is a commentary on the Yajnavalkya Smriti. An interesting question arises as to why Vijnaneshwara has preferred to write his commentary on the Yajnavalkya Smriti and not on Manusmriti. The Manusmriti was better known and more prestigious than the Yajnavalkya Smriti. At Yajnaneshwara preferred Yajnavalkya Smriti to Manusmriti. The question is why? If you compare Manusmriti with Yajnavalkya Smriti, we will find a striking difference. The Manusmriti is not a systematic one. That's one aspect. We will find one shloka dealing with the religion, the next is dealing with the law, the third is dealing with the morality. That is insofar as Manusmriti. And everything is jammed up insofar as Manusmriti is concerned. On the other hand, the Yajnavalkya Smriti is concerned, it is divided into 3 chapters, where the first chapter is called Achara, which deals with religion and morality. The second chapter is called Vyavahara, which deals with the law. And the third chapter is called Prayaschitta, which deals with penance. Thus, we find that in the Yajnavalkya Smriti, law is clearly separated from the religion and morality, unlike in Manusmriti, where all these are jumbled up. Thus, the Yajnavalkya Smriti was a great advance over the Manusmriti because in it there is a clear separation of law from religion and morality. This is what the Supreme Court said in subsequent judgments after Ayodhya and all those things. Narayana Dikshitu or many judgment in relating to Article 25 and 30, 25 and 26 is concerned. We can compare this separation of law from religion, morality, etc. with the similar separation made by the positivist jurist Bentham and Austin. Austin means the positivity. Law is a command of sovereign, he said, who separated law from religion. The Yajnavalkya Smriti was written later than the Manusmriti, and it shows a great advance over the later. Apart from that, Yajnavalkya Smriti is more concise and systematic. It has only about 1000 shlokas, whereas the Manusmriti has about 3000. Also, it is more liberal than the Manusmriti, particularly towards women, etc. And Vidyaneshwara, who adopted a secular approach towards the inheritance, naturally preferred Yajnavalkya Smriti to the Manusmriti since the former had clearly separated law from religion. Although Hindu law is regarded as having emanated from the Vedas, that is Shruti, the truth is that there is scarcely any law in the Veda, that is Shruti, and the law in Hindu law that has really emanated from these Shrutis. There were a large number of Shrutis, of which the surviving ones are Manu, Yajnavalkya, Vishnu, Narada, Apastamba, Gautama, Parashara, Vasishtha, and Katyayana, etc. According to Vigneshwara, the origin of property is popular recognition, and hence the basis of inheritance or succession is relationship by blood. While Jimatavana makes the text of Manu on this subject the foundation of his principle of inheritance. That is because Manu emphasizes the spiritual aspect as concerned. And Vidyaneshwara mainly relies on the text of Yajnavalkya because the latter prefers the matter of factual aspects. That is the difference in so far as the Manusmriti and the Manusmriti, which where the Jimatavana is seen, and Vidyaneshwara. Vidyaneshwara utilizes the Mimamsa Adhikarana as interpreted by Prabhakara, who is reputed to be an heterodox propounder of the Mimamsa Sutras. While the orthodox interpretation of the Adhikarana, as given by Sarvaswami and Kumaralila Bhatta, gives no support to Vidyaneshwara views. This is sense of a critic against Vidyaneshwara. Thus, we see that Vidyaneshwara utilizes the Mimamsa principles, particularly the Prabhakara school, for striking out a new secular path in the field of law. India is a country with tremendous diversity, innumerable religions, castes, languages, ethnic groups, cultures, etc. Hence, only a secularism and respect for everybody can keep the country together and make it progress. This is also the mandate of the Constitution. That's what we have seen in Article 25 to 30 of the Indian Constitution. Apart from above, the Mitakshara of Vidyaneshwara liberalized the law with regard to women. He provided for maintenance, that's what 125 here is, not only to the chaste wife, but also the unchaste wife and unchaste widow. Also, while earlier writers circumscribed women's property within the narrow limits prescribed by Manu, Vidyaneshwara included all property, however acquired within the definition. In this connection, his liberal views evoked protest from conservative scholars. There's a lot of problem that he has faced during that time. One writer going so far as to say that a particular rule was evolved by Vidyaneshwara out of his brain and hence deserved no consideration. However, ultimately all scholars recognized and accepted his views. Due to his progressive views, women became entitled to hold and inherit property. We should remember and honor contributions of luminaries like Vigneshwara. His profound understanding and interpretation of Dharma Shastra through Mitakshara has helped during shaping of contours of Hindu society and Hindu jurisprudence, and have left an indelible imprint on Indian society, as I have earlier said. We continue to learn from this timeless wisdom and utilize it in refining our legal systems and societal structures. In conclusion, the legacy of Vigneshwara and his Mitakshara serves as a shining beacon, reminding us of our rich intellectual heritage. Take for an example, if any country, dear friends, enter into a pact or a treaty with the Indian country or any other country, first they will look into the legal system of a particular country, how strong it is. Unlike a particular country's legal system is strong, no country will enter into an agreement with a particular country. But we have, insofar as a great the jurists like these people, where it shining beacon reminding us of our rich intellectual heritage. It urges us to maintain a spirit of inquiry, to not to shy away from questioning the status quo, and to continuously strive for justice, fairness, and equity in our laws. It serves as a testament to power of knowledge and the enduring impact of intellectual rigor. The Mitakshara and its author Vignaneshwara remain embedded in the soul of our legal traditions. It continues to shape our laws, our society, and our thinking, embodying a rich legacy of wisdom that we are privileged to inherit. And as we continue to engage with this legacy, we can continue to learn, evolve, and strive towards a more equitable and just society made applicable not only to our country but also the world as a whole. Vasudhaiva Kutumbakam. ಏಕಂ ಸತ್ ವಿಪ್ರಬಹುಧಾನಿತ್ ಸತ್ಯವು ಯಾವಾಗಲೂ ಒಂದೇ. ಜ್ಞಾನಿಗಳು ಅದನ್ನು ವಿವಿಧ ರೀತಿಯಲ್ಲಿ ವ್ಯಾಖ್ಯಾನಿಸುತ್ತಾರೆ. ದಟ್ಸ್ ಆಲ್. ಸತ್ಯ ಒಂದೇ, ಆದರೆ ಜ್ಞಾನಿಗಳು, ಪ್ರಾಜ್ಞರು ಅದನ್ನು ವಿವಿಧ ರೀತಿಯಲ್ಲಿ ವ್ಯಾಖ್ಯಾನಿಸುತ್ತಾರೆ. With this, I will conclude with the words of the so far as the Abdul Kalam ji is concerned. See, this country has given us everything. So I am standing here. Land is not belong to me. Nothing is belong to me. And my life is also temporary. Of course, we have to do very small thing to this country because we have won this. And this country has given everything. ನಾನು ಇಲ್ಲಿ ನಿಂತಿದ್ದೀನಿ, ಉಸಿರಾಡ್ತಾ ಇದ್ದೀನಿ, ಗಾಳಿ ಕೊಡ್ತಾ ಇದೆ. I have to do a small thing for this country. This is what I would like to tell all my students. Wherever. We need not do great things. Like Satish Chandra Bose, ಅವ್ರ ಥರ ದೊಡ್ಡ ಕೆಲಸ ಏನು ಮಾಡಬೇಕಾಗಿಲ್ಲ. ನೇತಾಜಿ ಸರ್. Do some very small thing. ರೋಡಲ್ಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಮುಳ್ಳು ಎತ್ತಾಕಿದ್ರೆ ಸಾಕು. That itself is a great thing for that we can do to this country. That should be there, our spirit, while we look into the spirit and the treatise what we are seeing in the Indian history is concerned. With this, I think from morning till now, I think we had the benefit of erudition insofar as the Mitakshara is concerned. We have discussed and erudition insofar had a benefit of the hearing Mr. Justice Shishananda on this aspect. And insofar as earlier also technical, the Vice Chancellor has also chaired this thing. So what we could do is, by the end of this validity, we have to assimilate ourselves. What was Hindu law earlier? What was in the middle period? And what was the content? Insofar as the interference made by the East India Company from 1600, after insofar as regulating act. See, that's what we can say. See, because of the regulating act 1774, in fact, it first time where the Supreme Court was established at Calcutta but for that act, our tradition has been interfered with the British, the what we call British their values is concerned. Because the reason is quite obvious, dear friends. The Indian Constitution, though, so we say it is a supreme. But if you go further in, ultimately, the Dharma is supreme. Let us be bound to the Dharma always. I shall be grateful to the Vice Chancellor and the law school for having an opportunity to share my few things with you. So thank you one and all. Namaskar.
Thank you, sir. Now I invite with a request to Honorable Vice Chancellor, Professor Bhattu Satyanarayana, sir, to presidential remarks.
The chief guest for this valedictory session, Honorable Justice E.S. Indresh Ji, the Judge, High Court of Karnataka, Sri Justice V. Sri Sananda Ji, the Judge, High Court of Karnataka, who is from the morning to now, still now, is totally day I spent here. The guest of honor, Sri Suresh B. Balbuleji, and the Professor Basraj Kubakadi, Sri Hamid Kumar Deshpandeji, the Senior Advocate, High Court of Karnataka, Dr. Renuka, the Assistant Professor, the Department of Law, the faculty members, the resource persons who have come from morning from different places and they are spending their whole entire day here, and they really enlightened us on the Bharatiya jurisprudence, research scholars, the faculty members from the different universities and colleges, and the students. First of all, really, the university is very gratitude towards the Vijnaneshwara Pratisthana Trust. This program is organized in collaboration with them in this university. So because of that, we could invite several judicial, the luminaries to the university. Definitely with this, the law department of Central Karnataka will definitely enrich and definitely it will benefit the students of the Central Karnataka. Definitely because they are sharing they are experience, that is, they are learning from the experiences of the legal luminaries. And not only today, last week also from 28th to 7th, they conducted a series of lectures by online. There also the students got that opportunity. Earlier also they are doing this very great job. Definitely because of this location of this university, we are benefiting out of this. And moreover, here, if we go into our legal system or our ancient judicial system, we can find many solutions of day-to-day problems. But now we are hesitating to revisit what is there in our ancient Indian history, particularly with respect to the jurisprudence. We are not, because we are not thought about this one, where in the school or in the college, unless the students join for the law, they are not aware about the legal system or law. Or even we are not exposed even to the fundamental rights or whatever fundamental duties, whatever the directive principles. Only who are prepared for the civil services or for competitive examinations, then only they go through this constitution only to prepare for the examination. But if a science student never encounter about this our constitution, and about when I entered into the university as a student, the people used to tell that the Manu followers are anti-progressive. I asked the person when one person told me that it is their anti-progressive, their Manuwadis, their Manu followers. I asked, what is Manu? Manu Smriti. The person who is propagating and telling he didn't know anything. No one knows about Manu Smriti, and everyone talks about Manu Smriti. Even no one knows about the Mitakshara. Whatever we know only, even the last law for LLB or LLM, whatever may be, I think they are only teaching about this IPC, CRPC, or this constitution. Nowhere I see in this Mitakshara or Manusmruti, whatever there. In the university, there is a need to go and to revisit, to do the research. There are good things is there. Sometimes those laws are formulated in those days, that is thousands of years back, based on those conditions. And today conditions are also different. We revisit and what is there good, what is not relevant today, what is relevant today, we can decode that. Like that, we can adapt and we can find many solutions. So now when our Sri Samandaji, when he is explaining everything about this Mitakshara, so far I am not aware about all these facts because I am not belong to the legal fraternity. Really, I was today enlightened about this Mitakshara. I realized what is the importance of the Mitakshara or this Bharatiya jurisprudence. Even the NEP 2020, when it is now it is already implemented in our central state of Karnataka. Therefore, for every student, they should be exposed to different these subjects. Apart from this core subject, that is a discipline specific subject. So that is for all round development. When we go into society, we need some kind of knowledge. Now, particularly if you look at the premier institutions, particularly IITs, IIMs, we can see that everyone looking for seat in the IIT or IIM, they feel it is a privilege, but we are also witnessing suicides in the IITs, IIMs, the premier institutions. Why this is happening? So there, if you revisit everything, you can find many solutions. And here, the teachers, the judiciary and the doctor should work without fear. Then only the country can progress. So for doing to revisit this, particularly as our Sri Anandaji told, they have some limitations. They have to go by the constitution when they deliver judgment. But for our university system, because when we are going for the research, we have no pressures and there is no restrictions. We have that freedom, we can revisit and what is there good and what is not good. Everything can be revisited and we can suggest, we can publish papers, not just for the sake of paper, research publication, but that should be useful to society, that should find a solution to today's societal problems. Even if you go to the Arthashastra, even in the introductory, in the morning, in the keynote address is also told about that with the justice. The Abdul Nazir is asking about with the implementation of the Uniform Civil Code, what will happen? This giant family system, where the property, where the income tax, everything, where they are explaining about this. So here the problem. Everyone is trying to accumulate the property. That is the problem that by this we are destroying the environment. We are not allowing the other animals or other living things to survive on the earth. If you see, the time will come to see everything in the zoo park or museums only. So it is a duty to protect environment. If we should also respect, or we should protect the entire the living systems. The environment is the ecosystem is very, very important. If you kill the snakes, the rats will they enter into our houses. Like this, the ecosystem is built like that in the nature, but we are destroying. For all this reason is people, some people because of the greediness, because they are accumulating the wealth for the future generations, for own family, future generations, they are accumulating and destroying everything. They are not allowing the other to live. But if you look at this, our Bharatiya jurisprudence, where the Mitakshara, whatever our Indian jurisprudence is concerned, how it is explained, how Ardhasastra is explained, this will really give many the solutions for many of our problems. Now it is the time for the universities to go for this research and show this solution to the problems. Definitely today, this is a really a fruitful seminar. Really, this I'm congratulating and the Department of Law, the Central University of Karnataka for taking up this one, and also Vijnaneshwara Pratisthana Trust for collaborating with our university. In future also, we will go ahead with this kind of seminars. Definitely, this region should benefit out of this UK. So, I always invite that whoever has this expertise, because their experience will definitely contribute for the knowledge transformation in the system, particularly for younger generations. With this, I thank everyone for patiently hearing from morning to now up to this one. I thank you one and all.
Thank you, sir. Now I invite Shri Amit Kumar Deshpande, Senior Advocate, High Court of Karnataka, and Trustee, Vijnaneshwara Pratisthana Trust, to propose vote of thanks.
Namaste everyone. I, on behalf of the Central University of Karnataka, Kalburgi, the Department of Law, School of Legal Jurisprudence Studies, and on behalf of Vijnaneshwara Pratisthana Trust, Martur, extend my heartfelt gratitude to His Lordship Justice E.S. Indiresh, Judge, High Court of Karnataka, for having taken his precious time and enriched all the audience here with his speech. I extend on behalf of the university and the trust my heartfelt gratitude to Honorable Bhattu Satyanarayana, the Vice Chancellor of the Central University of Karnataka, for having given a strong message to the students and the audience here today. I thank on behalf of the university and the trust the presence of Sri Suresh Bulbule, the trustee. I thank especially Shri Basavaraj Kupkadi, the Dean, Department of Law, School of Legal Studies, Central University, for coordinating and arranging this conference altogether with his efforts. I once again thank, and of course, we all are here for one purpose. I thank the students of all the law colleges, the students of the Department of Law, Central University of Karnataka, the faculty of all law colleges, especially the faculty and students of the law colleges of Bidar, Raichur, Sedam, and all law colleges from Kalburgi who have attended this conference today. I extend my gratitude to the advocates who have come here to attend this conference all the way from Raichur and other districts of this region. Now, once again, I thank, and of course, we would be failing and words would also fail in expressing our special gratitude on behalf of everyone here to His Lordship Justice V. Srishananda, the Judge High Court of Karnataka, for having given this elaborate, precise, crisp, and enriching understanding of what Mitakshara and the principles thereunder are, and how that will be useful for us for our further studies and our the very direction of the society. I thank on behalf of the Central University of Karnataka and the Vijnaneshwar Pratisthana Trust, the scholars who have given their talk in the technical sessions, Shri V. Krishnan, Shri A.R. Mukundan, the Honorable District and Sessions Judge Darbhanga, Shri Dr. Ramakant Sharma, Shri Dr. R. Naveen. I would also take this small opportunity with all apologies, but since His Lordship Justice V. Srishananda had told us that we should do some effort after participating in this conference today, we should do some effort to ensure that we are taking something back home and propagating something. I take this with all apologies. I am not at all well versed with Sanskrit language, but I would end my vote of thanks with at least one sentence in Sanskrit, especially for Justice V. Srishananda and for Dr. R. Naveen. Namaskara. Aham Kendriya Vishwavidyalaya Pakshataha Vijnaneshwara Pratisthana च पक्षतः भवतः गणमान्य जनानां संसाधना व्यक्तीनां च कृते हृदयेन कृतज्ञतां प्रकटयामि. Justice V. Srishanand, Justice E.S. Indresh, Honorable Judge Ramakant Sharma, Shri Krishnan A.R. Mukundan, तथा छात्राभ्याम विद्वान च प्रेस स्वयं सेवकान च धन्यवादं ददामि येन एतत् सम्मेलनं सार्थक सफलं च आयोजनं कृतं. धन्यवादः एकः सर्वः च. Dr. Naveen, please pardon me if I am wrong. Correct me also if it is so. I thank each and everyone who has been physically present here, who has been supporting us morally for the successful conduct of this conference today. Thank you one and all.
Thank you, sir.
I am sorry I have left out the name of the senior advocate, Mr. M.B. Nargun. I take this liberty always because I also am a pupil of the office of his senior, and therefore being his junior, I always take this liberty. Pardon, sir. I am very thankful to Sri M.B. Nargun for his presence here.
Thank you, sir. We will conclude today's session with the national anthem.
भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्छल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे जय.
So tea is arranged. I request all the participant dignitaries, invitees to join for the tea and meet and greet. Thank you.